Wonderful. Thank you so much. I'm delighted to be here with you. It's a great honor to virtually give this talk. This is a very dear project to me that will be published soon in the Antitrust Law Journal. So the title of my paper today that I will be presenting is Dynamism and Politics in EU Merger Control, the Perils and Promise of a Killer Acquisition Solution through a Law and Economics Lens. So a lot of words here in a title. What does this all mean? I hope we manage together to see through all that. I'm interested. I was very curious to see basically the interaction of innovation and politics in EU merger control. A lot of my research focuses on this area, and especially with regards to killer acquisitions and potential solutions that the Commission is trying to find to tackle this new phenomenon. So why I'm saying here that my lens is law and economics. A lot of people have analyzed killer acquisitions from a more traditional legal standpoint, and I thought it would be useful to throw in some additional law and econ, perspective in order to appreciate things perhaps from a different point of view. So let's see how we go. So in a nutshell, what this paper and this project is about. So killer acquisitions in Europe, in European merger control. Perhaps we have a gap. So these are essentially startup acquisitions. When we talk about killer acquisitions, mostly we talk about acquisitions of very small companies with no turnover yet, which, however, could raise competition or innovation concerns. And the problem in Europe is that, and when I say Europe, I mean European merger control, is that a lot of these transactions fall below the thresholds of the EU merger regulation. So there has been a lot of debate about whether there is a jurisdictional gap, whether the Commission can have any say over those transactions. And in fact, it cannot, as I will explain later in this talk. So at the European level, at least, we cannot review those transactions. This has been seen as problematic, and the Commission has proposed some solutions. We'll look at those in a second. So what has happened so far and why we have these thresholds at European level? So there is a long history behind the thresholds that we have. Essentially, consciously, the EU, together with member states, decided to have a threshold-based merger competence allocation system in EU merger control. And there was a reason for that. So the main reason was they wanted to have clear-cut allocation of competencies between the EU Commission, the EU level, and member states, so national merger control. So we'll see the only exception to that is case referrals. And why is that so? Why was that choice introduced? Well, it was a nice way to exclude jurisdictional competition between the Commission and member states. So the spheres of competencies above and below thresholds, in other words, would be very straightforward, okay? One will not interfere in the feet of the other, so to say. So this was a very nice, neat, clear-cut, simple, and predictable system, also for companies. And for those transactions that fell above thresholds, it was also centralized, meaning only the Commission could look at those transactions. In a sense, everybody was happy with that equilibrium, so to say. But now, since 2021, some things changed. A lot of discussion about killer acquisition was happening. And the Commission decided to use one of its exceptional mechanisms, one of its case referral mechanisms found in Article 22 of the EU Merger Regulation. And it tried to use it in a different way than it was used before. As I'm saying here in the slides, it tried to unilaterally repurpose it. Why unilaterally? Without the agreement of member states, okay? So what happened? A lot there has been a consultation about this, a lot of responses. The commission replied to those responses and so on. So a lot of people were saying, practitioners, for example, there is not a big gap. It's okay if we use Article 22 to cover those few killer acquisitions perhaps we have below the thresholds. And the commission was also happy with that solution, kind of, because they thought, oh, now we can have a more flexible tool to capture those exceptional transactions below thresholds. So Article 22 was seen as a good way to fill gaps without, majorly revising the system. However, in this article, and this I think is my main thesis, is that this solution is not satisfactory enough for two reasons, basically. First, if the EUMR thresholds that we still have had some problems, and the two problems that I identify in my article through a law and economics lens is what I call a deterrence and an externality problem, and I will explain later what I mean by that, were not effectively solved by this Article 22 solution. And second, and perhaps most importantly, this was not a minor tweak or an exception to the system. This change, this repurposing of the Article 22 introduced a major transformation to the system of competence allocation in EU merger control. Why? Because, as I'm saying in the paper, the system was transformed de facto from a zero-sum to a non-zero-sum game, using here game theoretic terminology. Essentially, the Commission tried unilaterally, as I said, bypass member states, avoid the revision of the EUMR, an amendment of the merger regulation, and avoid essentially renegotiating the basic agreement we had with the introduction of the EUMR with member states. Article 22 has other kinds of faults, if I may say so. So one of those is that it's a voluntary mechanism. So unlike the thresholds that are quite fixed and they're triggered, when you hit them, or they're not if you don't, here there is an element of discretion. So it is a little bit unpredictable if member states will decide to refer a case or not for their own reasons. They don't have to, justify it, essentially. And the Commission the same. They can accept or reject such a referral from member states for their own reasons. The second thing that Article 22 introduced, based on what I'm suggesting here, the move from zero-sum to non-zero-sum, is essentially for below-threshold transactions. Now we have jurisdictional competition between the Commission and member states about who will establish jurisdiction of a potentially problematic deal below thresholds. So the dynamics are different to what they used to be before. Sometimes this could be good, but it's not guaranteed that it will always be good, as it is often the case with competition. And I will explain later why. So in a nutshell, I'm suggesting that this is not the optimal or the most sustainable solution as the Commission and others have portrayed. Okay, so now I will try for the rest of my talk to convince you that what I'm saying here makes sense. Let's see how we go. Okay, the first part of my paper deals with economic. Basically, I'm trying to summarize economic literature and based on that, launch my paper. So what do we mean by killer acquisitions? Here we essentially talk about transactions that try to eliminate or suppress future competition and innovation. So it's not about now, it's about something happening in the future. The challenge, though, is that in advance, ex ante, it's very difficult to distinguish cases of harmful killers that could create anti-competitive concerns and potential beneficial M&A. Very often we want to encourage those startup acquisitions and, essentially the takeovers of small companies and find a way for them to find a way to the market or financial support by a larger player and so on. So we don't want to be very heavy-handed in this situation. Also, the economic literature suggests that perhaps in certain sectors, the risk of such acquisitions, meaning killer acquisitions, is higher, for example, in pharma. And there is a whole discussion whether in the digital sphere, the risk or the parallel or the risk are similar, and so on. Another strand of economic literature, for example, by Thomas Volkmann and so on, suggests that perhaps the law is the problem. And what do I mean by that? There has been a big wave of digital mergers and acquisitions, and many of those were found to be below reporting thresholds. In fact, the study by Volkmann that I mentioned suggests that those acquisitions happen disproportionately below thresholds and intentionally so. Why? Perhaps the suggestion here is that the law may induce strategic behavior. It means what Volkmann showed is that, as the thresholds for reporting transactions in the US increased and the likelihood for detection and enforcement decreased, we could observe that more anti-competitive acquisitions happened below the thresholds. So in a sense, we could see more transactions happening below thresholds and smaller transactions happening in order to avoid those thresholds, avoid reporting those transactions essentially. Now, this problem could be quite significant in Europe. Why? Because in Europe, because of the structure of the EUMR thresholds, below those thresholds, we don't have any scrutiny whatsoever by the European Commission. And very importantly, in the EU, we don't apply anymore, since the introduction of the EUMR, antitrust rules to mergers and acquisitions. I will explain later exceptions we have to that, but these are quite recent. So the risk of under-deterrence and perhaps systematic under-deterrence until recently was quite significant. So the benefit of the EU regime was that it was quite certain regime. If you hit the thresholds, you could report, you know exactly if your deal will hit those thresholds or not. But the downside is that it was a bit of a fixed regime. And in this context of innovation, startups, and killer acquisitions, that regime does not seem to be very agile to capture those acquisitions. So I would say legitimately, the Commission had concerns about how to go about and solve this catch-22. It's interesting here perhaps to compare the EU position against the US position. What do I mean? In the US, although there are reportability thresholds, the authorities, the DOJ and the FTC, can prosecute any transaction even if they are below thresholds. So the thresholds are there only for transparency and reportability purposes. But in terms of enforcement, they do not block the authorities from going after problematic transactions. In the EU, the thresholds are a bar to any enforcement. The Commission has no authority whatsoever below them. And at the same time, in the US, we have pluralistic enforcement, meaning we have concurrent jurisdiction, not only by two federal enforcement authorities, the DOJ and the FTC, but also the states attorney generals can also prosecute mergers and acquisitions in parallel to federal authorities. Okay. I'm trying to make a point, basically, that under-deterrence is a serious concern in Europe. Now, do the new solutions that the Commission tried to introduce address this problem? I'm suggesting in my paper perhaps, but perhaps in a sloppy way. Why? The Commission tried to do two things. Okay, first, they introduced Article 22, that they tried to enlarge its scope. And so we could have selective enforcement a little bit closer to the US model, but that enforcement would be unprincipled. As I said, referrals are discretionary. So we wouldn't know, there would be a lot of uncertainty about whether a case could be referred or not. It would be a subjective judgment, in other words. And that could lead to over deterrence. Some of the under deterrence could be filled, that gap, through another solution that the Commission introduced. We now have a Digital Markets Act also in Europe, and there is an Article 14 based on which all digital platforms that are designated as gatekeepers, they have to report their transactions to the Commission. So that mechanism perhaps increases the likelihood of detection of those transactions. However, under Article 14, the Commission does not have any enforcement powers whatsoever. So their member states could have some tools to prosecute such transactions at national level, but for deals that are really cross-border, that enforcement perhaps would be limited. So essentially, perhaps we close some of the under deterrence gap, but not all of it. Okay. So leaving the economics and coming to the politics, that I think this is the most interesting aspect that my paper adds to the discussion on killer acquisitions in the context, in the European context, and perhaps that hasn't been highlighted so much in the past, is that the EUMR thresholds have a certain political dimension. What do I mean by that? They were purposefully decided, they were part of the political deal that the Commission struck with member states. There was a purpose why they were very high, okay? And in fact, when the EUMR was first introduced and the first proposals for the EUMR were introduced, they were quite conservative because the Commission knew, in order to convince member states, that already had merger control competence at the national level, they were not willing to give that away. So they had to come up with something that would make sense, politically speaking, for an agreement to happen. And we will see that if we look, for example, the 1973 proposal for a merger regulation that was rejected, we will see that initially the Commission has proposed a broader framework for European merger control, including looser threshold and a call-in power. That was rejected by member states. And we will see why I mentioned this call-in power. This call-in power based on research, court decisions by the EU courts, it's important in the context of case referrals. Okay, so why were these high thresholds and these conservative thresholds were agreed? Essentially, it kind of served everyone at that point in time. Remember, the merger regulation was introduced in 1990. So member states prefer to have, a contained, as I say here in the slides, EUMR, rather than having antitrust enforcement under antitrust rules, which is primary EU law, by the way, which means that the Commission will have the first word on that. The EUMR is secondary law, so that makes a difference. And which means that, and the Commission has threatened to do so. The Commission has gone after mergers through Article 102, and minority acquisitions also through Article 101. So they had the card in their hands to, push a little bit those political negotiations. So the member states eventually agreed based on that understanding. And at the same time, also industry, meaning companies, were happy having a one-stop shop, meaning only the Commission to deal with, having to report the transaction only at the EU level rather than having to file separate notifications in each and every member state that had the merger control regime in place. Okay, so the EU dimension, which reflects the thresholds, in another way to say transactions that have that hit those thresholds, has been agreed between the EU and member states because essentially it was seen as an objective jurisdictional criterion. Okay, and the intention here was to capture large cross-border M&A, presumably those that would those deals that would involve at least 3 member states. And indeed, if you look at the thresholds rules in Article 1 of the merger regulation, you will see an exception, what we call the 2/3 rule, where transactions that predominantly involve 1 member state, they're excluded. Okay? We think that it's more appropriate for that member state to look at those. So we assume that those transactions do not have, in other words, cross-border or EU impact. One nice way from an economic point of view to look at those turnover thresholds and the 2/3 rule is as a proxy for the geographic market that is affected, okay, that we should look at to evaluate competition effects. It is also interesting to note that at that time when merger regulation was introduced, there was an impetus of allowing cross-border mergers, especially those involving different member states. Markets were unconcentrated. Markets was usually concentrated along national lines at that point. So this whole, introduction of EU merger control was not seen as a problem, was seen as part of the solution, facilitating EU integration and the internal market rather than being a barrier. Okay. One good thing with the passing of time that happened with the thresholds is somehow they were de facto lowered in the sense that they had not been changed in terms of numbers, but with inflation, more deals fall within them. And for the same reasons, due to the integration that we could see within the internal market, the 2/3 rule also lost its bite. Okay, now continue with the politics. It is important to understand, as a matter of the political and the legal background to EU merger control, there were 3 basic principles upon which the EU merger regulation was based. Those were the one-stop shop, subsidiarity, and legal certainty. And what do I mean by one-stop shop? We mean that transactions that had the EUMR dimension that fell above the thresholds were exclusively to be reviewed by the Commission. In other words, the Commission had exclusive jurisdiction. Only them could look at those transactions and nobody else. So, as I said earlier, companies that hit those thresholds knew that only the Commission would look at their transactions, and they only had to notify the Commission of their deal. So, for them, presumably, it was a more simplified situation. Now, for deals that fell below thresholds, member state had competence if they had such laws in place, but this potentially meant multiple reviews. On the other hand, there was another principle, the principle of subsidiarity, that is central to EU law. It's also central to EU merger control. And what does that mean? It is the principle that the EU should only act when member states cannot do so because of the scales and effects of that action. So the thresholds were seen also as a convenient filter to distinguish significant spillover efforts, not only any cross-border deals with a cross-border aspect, but those that had a significant cross-border element, in other words. And why the Commission should only act in those cases? Because the Commission could be seen as best placed to internalize externalities that would be visible perhaps in cross-border cases with EU impact, in other words. Now, as I mentioned earlier, the thresholds nicely divided competencies vertically between the Commission and member states, excluding concurrent jurisdiction over the same transactions. So they didn't have to argue, in other words, who will take jurisdiction over those cases. The only exception was case referrals, upwards and downwards, meaning from member states to the Commission or from the Commission to member states. But it's very important to understand that those exceptions were not real exceptions because they never undermined the system of one-stop shop we had in Europe. And this is key. And one of the key points that I make in my paper, that the latest extension of Article 22 in fact undermines this. Okay, so it goes against the principle of subsidiarity, one-stop shop, and legal certainty that are fundamental to EU merger control. Now, there are some positive things about case referrals. So referrals are good because they allow more flexibility to be introduced to the system. In other words, they allow reallocation of cases to the most appropriate authority, exceptionally, given that the thresholds are quite fixed. Okay. So they improve the system. However, always those referrals, as I said, were in line with the basic principles we have in EU merger control: subsidiarity, legal certainty, and one-stop shop. Those referrals were introduced for political reasons too. So we see the political dimensions here as well. They were agreed to serve certain interests of different member states. For example, one of the case referral mechanisms, we call it the German clause for obvious reasons. And Article 22 that I'm talking about today, we call it the Dutch clause. It was Netherlands that suggested this provision because at that point they didn't have any merger control regime in place, and they felt that that clause was needed for them to refer cases upwards to the Commission to look at them on their behalf. Okay, so I mentioned already that referrals are voluntary, so there is a discretionary element introduced to an otherwise objective system. And that may be a way for self-interest to infiltrate EU merger control. Okay. Now let's take a step back and see why we have Article 22 and what happened along the way. Originally, so when the EUMR was introduced, Article 22, I mentioned Netherlands earlier, the Dutch clause, right, was part of the EUMR bargain, same as the thresholds. Why? It was seen as a way to further subsidiarity, because Netherlands and other smaller member states did not have merger control, so they would they would refer cases to the Commission to look at them on their behalf, because they felt if the larger member states such as Germany, France, and so on had merger control, perhaps they would be disadvantaged. Those member states would look at those transactions only considering the national interest and not smaller member states' interests. Okay, another important thing to note here is that at that point, as part of agreeing to the introduction of the EU merger regulation, is that the Commission and member states agreed to disapply the implementing regulation that we have for antitrust rules, Article 101 and 102 TFEU, which means that the Commission could not apply antitrust law to merger transactions, essentially. So there would be no alternative in other way unless there was a referral for the Commission to look at those transactions. Okay? They made that commitment to member states in order for them to agree to the EUMR. Okay, a few years later, after having some experience with Article 22, the Commission thought of streamlining the practice. So they thought, oh, wait, when we have joint referrals by 2 member states or more, in this case involving not national cases but cross-border cases, okay, with cases with cross-border effects, then the EU would be best placed to look at those transactions. So it would be good to avoid multiple filings at the national level. And we would encourage that those cases are referred to the Commission and we have one-stop shop review. Okay, that happened. However, the limitation was that only the case could be reviewed for its effects only in the territory of the referring member states. The Commission would not have competence for the whole of the EU unless all member states refer the case. And this was seen really as a temporary mechanism until the thresholds were reviewed, but that never happened. You know, the Commission was optimistic, but they never convinced the member states to lower, for example, thresholds. We see some evolution in Article 22. In 2004, paragraph 5 was added that said that the Commission could invite member states to make a referral. But at that time, you know, Commission documents make clear that the Article 22 was seen as a post-notification referral mechanism. And in general, Article 22 was never intended to be a general basis for jurisdiction, for the Commission asserting jurisdiction over mergers against the clear-cut threshold. So the rule was a threshold, and a very, very small exception was Article 22. In fact, Article 22 was rarely used. And we see this by the Commission statistics that I cite. So for 25 years or so, we had 51 referrals. Since the change of its practice in 21, we had 10. So you will see how the dynamics and the proportion here of cases referred change with the policy change. Okay, so let me try now to explain a little bit the context around Article 22, because Article 22 and its repurposing happened with the guidance that the Commission issued in 2021. And the intention here was to capture any mergers below the thresholds, meaning any mergers below even national thresholds of national merger control rules. And this was the controversial part. Not for member states such as Netherlands, when they argued for this clause in 1990, and still Luxembourg is the only member state that doesn't have merger control rules, but they're considering one. But from member states that they had existing law. So although they had existing rules and their transaction did not fall within the existing rules, they could refer cases. So this was here the problematic element. Could they do that or not? The first test case that the Commission used Article 22 to put to use its new policy was the EUMR Grail transaction that involved two US companies. They had no EU activities, the target, and no filing was required, no notification in any member state. So in other words, it was a bit of a weird case. It was a first that this happened in the EU. And soon after, in fact, we had an appeal that led all the way up to the Court of Justice. And we have the EUMR Grail now judgment from the court that overturned the Commission policy. And I thought they were right. So essentially here, the question is whether referrals of mergers without an EU dimension, meaning below thresholds, were allowed from non-competent national authorities, okay? And the court said, no, this is not possible. The Commission now is trying to reposition after that decision, the judgment by the court, and say, oh, wait a minute, we can still use Article 22 referrals based on competent, on national competence by member states who have national calling powers, okay? This is, perhaps they don't hit the notification threshold at national level, but they have calling powers. And now we see that more and more member states introduce those powers for obvious reasons. The previous commissioner also suggested that perhaps we should look for the long term if, capturing any below threshold transactions, regardless of national competence, could be a potential option. At the same time, I said we have Article 14 of the DMA, the Digital Markets Act, that asks to report any transaction. And why is this important in the context when we discuss EU merger control? I mean, the DMA applies presumably to only a few transactions and only in the digital sphere. So here, although the Commission has no enforcement powers under the DMA, okay, it was a conscious decision not to amend the DMA, and they chose to introduce a more narrow tool within the DMA for digital mergers. But the limitation of this was that they cannot order a transaction to be undone or the remedies. It's only a transparency regime. However, there is a catch here. The Commission thought that, there is a subparagraph in Article 14 that says that the Commission will inform member states about the reported transactions, And then guess what? Member states can use Article 22 to make referrals to the Commission. So they found a nice roundabout way to de facto reform the merger law without reforming the merger regulation. And at the same time, another irritant perhaps here is that Article 102 TFEU. Now we have a new judgment from the court, another very important judgment in the area of merger control, the Towercast judgment, that says, wait, Article 102 TFEU can also be used to go after transactions, merger deals exposed, okay, that were not reported. Remember, as part of the deal between member states and the Commission said we will never use, antitrust rules. We disapply the implementing regulation. But now the court said that national authorities can use Article 102. So we see again that the dynamic and the available tools and the actors, member states or Commission, and what options they can use to go after mergers has changed. And this has changed the game quite significantly, I suggest. So if you one takeaway that you can take from this slide is that above the thresholds, only the Commission is exclusively responsible to look at transactions. Before these changes that I just mentioned happened, below thresholds, only member states could be there. Only member states that had some kind of national merger control rule. But now we see that Article 22 of the EUMR, the case referral mechanism, is also there. So the Commission can gain jurisdiction over those transactions. And Article 102 of TFEU is also there, which means that member states can also assert jurisdiction of those transactions in certain cases. This creates a question of what is the relationship between Article 22 EUMR and Article 102 TFEU that I discuss in passing in the paper. But the important point is that it is not clear, there is no clear hierarchy in law or in practice of how those provisions in the law and jurisdiction of the Commission or member states interplay are prioritized one over the other. So there is a lot of uncertainty. Okay, why all this happens? I'm trying to take one step back and look at the political economy of all this happening. Perhaps you've seen the political guidelines of the President of the European Commission and the Draghi report talking all about European competitiveness, innovation. And in the context of that, you will see reference to killer acquisitions of European startup innovative companies by foreign corporations. So this is the concern here. So killer acquisition is something that in this context of innovation and competitiveness bothers the Commission quite a lot. Okay, they see it as a threat to the internal market. And another threat that they see is that a lot of member states have moved fast to try to capture those deals, but they see the fragmentation there quite problematic for the EU, given the global race that we see for tech and industrial leadership. So the goal for the Commission was not only to, cover competition gaps, but also and essentially to gain EU competence over member state competence over below threshold transactions. And I argue this is one of the main reasons, from political economy point of view, you can rationalize this choice of the Article 22 mechanism that they wanted a fast solution to fix that problem. Okay, so Article 22 is good in another way. It extends dramatically EU merger control, meaning, no gaps are left. But the expansion is quite significant and against the existing system, the logic of the system of EU merger control. So I call this, and not only me, a backdoor, extension. The Advocate General Emiliou says the same. And essentially, it was an indirect way of revising the thresholds that we have and introducing a case-by-case system for below threshold transactions. So Article 22 essentially became from an exceptional tool to a catch-all tool introducing de facto calling powers for the Commission that we saw that were rejected by member states when the EUMR was introduced. So what does this tell us about the presumption that we had about European dimension mergers that were thought to catch cases with significant cross-border effects? That presumption was conclusive under the original Article 22, meaning only mergers with national impact could be delegated, from member states that did not have merger control to the Commission to be looked at under Article 22. In 1997, with the revision of the EUMR, that presumption was rebuttable, but within certain limits, meaning we knew that cases could be reallocated and referred to the Commission, but only from competent member states, meaning where there will be a filing notification, for example, and in cross-border cases, meaning when there will be at least 3 member states involved. Okay. Now, with the latest extension of the presumption, this is limitless, and potentially any below threshold merger whatsoever, even from a single member state based on calling powers, could be referred to the Commission. Why is this problematic? Going back to the same table again, I think one of the main highlights of my paper is that, before we had mutually exclusive competencies, what I call a zero-sum game, in EU merger control, meaning that the Commission could only look at transactions above the EUMR thresholds and member states only at transactions below. But now, for below threshold transactions, we have de facto concurrent competencies and non-zero-sum game, in other words, where both the Commission and member states can look at those cases. And in fact, this is so uncertain that we don't know in advance when will this happen and how. And some member states perhaps are disadvantaged in this context. Okay, what is the good about this change? The good thing is that perhaps there could be some cases with cross-border effects, killer acquisitions that could have cross-border effects, where we're not captured above, or not captured by those thresholds. And in those cases, the Commission could use Article 22 to ad hoc centralize enforcement, relying on member states. So, in other words, the EU now sees itself as a trustee of effective merger enforcement, also below threshold transactions, which, institutionally speaking, is more similar to its role for Antitrust or the DMA. Okay. However, it's interesting that with Article 102 TFEU and national enforcement as alternatives to its centralizing, tendency through Article 22 EUMR, perhaps it will not be successful to centralize enforcement always, because remember, member states can always opt not to refer a case. It's their prerogative to do so. Nobody can convince them otherwise. So there is no disciplining mechanism in other way to centralize enforcement when this makes sense. Okay. Now, I'm also discussing in the paper that Article 22 is not a solution to the deterrence and the externality problems of the thresholds. In other words, not all transactions that deserve EU scrutiny are detected and referred. The referral practice is discretionary and unprincipled. So essentially, it's a suboptimal solution. And not only that, we also have, through its introduction, some institutional side effects, in the sense that this has been a one-sided reform. And now, with the change of the rules, there is no safe harbor based on thresholds for companies anymore. And most perhaps worryingly, there is a disproportionate burden and uncertainty for small transactions that perhaps need to be notified in all member states, and they're unsure, even if they're not notifiable based on calling powers, if they will be referred to the Commission, rather than bigger transactions that they know they can go directly to the Commission and take advantage of the one-stop shop. Also, the regime effectively, the EU regime was transformed from one based on ex ante mandatory notification to one that is voluntary and ex post. And this is concerning because judicial review is limited with regards to referrals. Remember, they're voluntary. And third party rights in this process are also limited or non existent. So this creates some institutional concerns. Now trying slowly to go to the solutions, what we can do about this and how can we see it going forward. The fixed system of threshold-based competence allocation could be seen as a preemptive federalism system that has its limits, so this is understood. And perhaps moving towards a dynamic federalism model would make sense, approximating the US model. The fact that the Commission tried to introduce jurisdictional competition between itself and member states through an expanded Article 22, it's understandable from a political perspective, meaning it was a path-dependent solution. It was the best solution they had in their hands, given their political constraints, given the fact that they thought, if we're to revise the EUMR and renegotiate politically member states, it would be a mess, and who knows what we would end up with. We don't know. It was high risk. However, what I find ironic, and I note in the paper, is that, in order to successfully centralize enforcement ad hoc, they would have to negotiate with member states anyway, that given the fact that the referrals are voluntary, okay, in individual cases. Now going forward, I suggest a hybrid system, that is based both on incentives and certainty, so combining elements of the EU and the US system. And in the interest of time, let me move and discuss the solutions, the alternatives that I'm suggesting. So those solutions could be understood as, placed between a continuum of decentralization and centralization alternatives. And the criteria that I use, the law and economics criteria that I use to assess those alternatives is how well they internalize externalities, they capture cross-border cases, for example, they save transaction costs, or they improve incentive costs, meaning deterrence effects, okay? So I discussed four alternatives. The first would be ex ante centralization. What do I mean by that? Reforming the thresholds themselves. So, the main system that we have in place, and expanding EU competence that way so that the EU can look more of those transactions. This is a bit of a rough mechanism and not so effective, probably. So I'm not arguing for that. Another way would be to reform case referrals and allow for ex post centralization. And this is, I think, is needed anyway. So this is the minimum that we need to do to streamline case referral practice in line with the principles of EU merger control and so on. A third alternative is to move towards the US model, where anything can happen at any time by anyone, so to say, meaning full flexibilization and decentralization, meaning EU liability would be regardless of thresholds. Remember that in the US, reportability thresholds are not tied with enforcement powers or national competence for that matter. And same, member state liability should be unlinked from national filings. This way, we would have fully concurrent competencies, both at EU and national level. There would be some downsides with this, for example, over-deterrence potentially that we could think, but perhaps could be solved through self-coordination mechanisms as in the US. Now, the fourth alternative is the most complex, but I think long-term, the ideal will be to move more towards that way. And that means, reforming the case referral system, but not only upwards for the Commission to benefit from referrals, but also downwards in cases that make sense. And in general, strengthening network governance in the model of the ECN, the European Competition Network, that we have in the context of antitrust law. and allow also for centralized monitoring and judicial review, meaning some institutional improvements also to the system. This way would be able to tackle externalities, negative outcomes, and also improve the effectiveness of the system without sacrificing basic principles of the EUMR, such as subsidiarity, one-stop shop, and so on. To conclude, a lot has happened, or let me say it differently. A lot has not happened for a long time. So for 35 years, everything was calm in the sphere of EU merger control until we had this change of policy at the EU level through Article 22. So the turnover thresholds were part of a political deal struck with member states. And it was seen as a positive thing, as something that created a very clear-cut and certain system of competent allocation, regardless their limitations. So there was there for a long time for some reason. Now, with Article 22 in the game, killer acquisitions could be addressed. In other words, more flexibility and dynamism is introduced in EU merger control. However, also discretion, as the referrals are discretionary. And that means more unpredictability and potentially arbitrary merger decisions. So there is a political element introduced there. This affects, in turn, business incentives. So what kind of mergers are proposed, and competition authority strategies, what kind of deals they choose to refer to the Commission or they choose to enforce nationally based on their own rules or tools. And we see now that the court in the Illumina Grail case narrowed a little bit the possibility for referrals based on Article 22. So only referrals based on national calling powers, meaning from competent member states, are possible. But this does not undo the fact that still we have a non-zero sum game here, meaning the threshold system that we had and the competence allocation system that we had in Europe essentially changed in quality, in other words. And why I'm saying this, and I'm repeating this non-zero sum terminology, as I mentioned earlier, through Article 22, the Commission could centralize enforcement, but at this point in time, such centralization is uncoordinated. There is no disciplining mechanism that they can do that. So that means that there is full jurisdictional competition between the EU and member states. And given this, it's not a given that they will agree to give out their competence in all cases, or in cases where this will not be to their own self-interest. This suggests that, we need to keep on looking for solutions and effective reforms, and with a view towards, optimizing the system and making it more efficient, in line with some principles that I cite here in the slides, and more importantly, with a view towards, improving EU competitiveness and innovation, which is, in all talks of all European Commission related stuff, I would say, in the last few years. And I will stop there. Thank you so much.